I think of myself that way, but
Often the wife has to put up with a lot of grief
yeah,
on the second half of the marriage. And the judges, most of whom are still old white males,
right.
understand that concept. That's why when there's a dispute between the children by the prior marriage and the surviving spouse, the wife usually comes out on top, because the judge's attitude is that, listen, she married him and she was still living with him for 20 years. She fed him, she cooked for him, she cleaned the house, she did all these things. She kind of deserves whatever she can get. And there's that's not the legal principle, but that's often how the triers of fact decide the cases.
Okay. Well, what can the children do? Aren't they entitled to an accounting?
Well, yes and no. I mean, not an accounting in its strict sense, but they have the right to write a letter or to actually have a lawyer do it for them if they want, and to compel the surviving spouse to give them a report. What are you doing with the money? Now, that presents a problem in and of itself. If they just send a letter themselves, they feel awkward doing so because, gee, they never got a report from their father. Now, why are you asking for a report from me? And if there was friction before father died or before that letter was sent, there's definitely going to be friction thereafter. And again, as I said, sometimes the wife's position is, are you kidding me? Don't bother me with this. I was married to this man for 20 years. He was a pain in the rear end.
Yeah. How dare you?
How dare you? On the other hand, you're right. They've got a right to a report. And so often what they have to do is they've got to hire a lawyer to find out what's going on. And sometimes what's going on is perfectly appropriate, in which case they spend a lot of money on a lawyer finding out that she was doing the right things anyway. But you're right, they do have a right to a report.
Okay. Don't the children, or might not the children, see the surviving spouse as basically just standing in the way of their inheritance? And do we have the motive for a mystery novel?
Oh, if I really wanted to make some money, Mike, I'd just write a book or a series of books. That's true. I can't tell you how many adult children by the prior marriage would come in to see me and explain to me that they're very upset about this because, after all, their father's leaving this woman money that he inherited from their mother. And they just don't think that's right. And I'll try to lead them into what I think is a more enlightened view of the situation by asking them questions. Well, how long was your father married to his second wife? Well, 30 years. And during that period of time, they lived together? Yes. And she cooked for him? Yes. And she cleaned the house for him? Yes. And when he had to go to the doctor, she drove him there? Yes. And when he became incapacitated, she was there to handle all of his personal needs? Yes. And I'm waiting for the little light to go on in the child's mind. But instead, it usually winds up with the child saying, but you don't understand this, Mr. Demery. This woman just married our father for his money. To which I say is, well, frankly, if she did, he got the better part of the deal. And that usually doesn't go over too well with the children by the prior marriage. But the fact of the matter is that you can try to explain this to the children by the prior marriage as much as you want. They just don't see things the same way you do. What's important is not that they see things the same way you do, but that they try to be educated into seeing things as how the judge will do.
Yeah.
For example, if a child goes into court and wants to say that our stepmother shouldn't have been able to use $100,000 to buy herself an S-Class Mercedes, that's not a reasonable support, care, and maintenance. You know who's going to win that?
The mother.
The mother, the surviving spouse. It might be one thing to give a bunch of money to her third husband or something like that. That's inappropriate. But she's going to be given pretty liberal flexibility. Keep in mind as well, a lot of times that there will be, especially in a long-term second marriage, there'll probably be some community property there. And she can do anything she wants to with her half of the community property. Now, how is she going to react to children by the prior marriage who are, from her point of view, bugging her about giving them a report? Is she more likely or less likely to leave them anything?
These impertinent people.
Exactly.
All right. Should an independent trustee be used?
Yes, but that's easier said than done. Keep in mind, when you're doing estate planning, you're doing it for a husband and wife. They're usually there at the same time. Now, the question becomes, who's your client? Well, often they both are. And it's important to get a conflict waiver because you might say, conflict, we're married.
Yeah.
Well, yes, and that's my point. Because you are married, you do have conflicts. But if you do, you usually get a conflict waiver and you plan the estate for both of them. And they both put their property into the trust. They have provisions which mirror each other. It's going to be held for you for your life. When you die, it goes to your kids, etc. And you'll suggest at times that maybe when the surviving spouse dies, an independent trustee will come in. And I've yet to see the family, the husband and wife, react well to that. The husband's attitude is, "You kidding me? I've been managing this property for 50 years. Nobody's going to take it over from me."
Yeah.
And the wife will say, "Are you kidding me?" I mean, she won't exactly put it this way, but she'll look at me like, "I've been putting up with him for 50 years, for 30 years. Nobody's taking this out of my control." So usually you'll get one or the other will be the trustee.
Okay. We just about have 3 minutes left, just to let you know where we are. What about the healthcare directives and durable power of attorney for healthcare? So, who do you put on that thing?
I think you put your spouse in discussion. The bottom line is, there's this concept that the attorney is the attorney for the family. That's not true. The only attorney for the family that I know of was the consigliere that existed in Mary Puzo's novel, The Godfather. You are the father's lawyer and maybe the stepmother's, but you're not the children's lawyer. And you shouldn't hold yourself out as doing that. Also, because this is a temperate climate and they got to make medical decisions on us pretty quickly, you don't want the doctor to have to get the consent of the spouse and all of the children by the prior marriage, assuming that they will all agree, because all it has to happen is one of them disagrees. So I think you make your spouse that person to make that decision, and you trust that she's going to do what you want her to do.
Okay. Well, we're getting into a wind-up phase here, but aren't estate fights expensive?
Very expensive. Hourly rates, you're going to run $400 or $500 an hour for this kind of thing, and that can build up very, very rapidly. You have $1 million estate, you can expect that at least 2/10, a fifth will be spent on attorney's fees. The problem is it's almost all a winner-take-all situation. Either the wife's going to win and get it all, or the kids are going to win, in which case the wife's still going to get it all until she dies. So it usually doesn't behoove you to file these lawsuits. On the other hand, sometimes you just got to do something if you're the children. If the wife's out there spending everything on jewelry and all kinds of things that are high risk and are just dissipating the estate, there could be $4 or $5 million there that's going to be frittered away. And sometimes the children are going to have to step forward and do something to block that. In which case the court will, if there is a breach of fiduciary duty by the surviving spouse, will step in and appoint an independent trustee to manage it.
All right. And now we just have a very brief time here, but as an alternative, of course, it's better to settle, to maybe work with a mediator or something like that. It probably can save the family a considerable amount.
Well, keep in mind that the concepts such as mediation are based upon the principle of settlement. But in order to settle a case, you can't make people settle a case. You can make them go to trial, but you can't make them settle. In order to settle, you got to get the agreement of at least 4 people. Party A, Party B, and their 2 lawyers. Any one of those 4 people doesn't agree, case doesn't settle. So what might seem like a fair compromise to you seems like an unfair compromise to me.
Okay, we're going to have to wrap it up right there, Mike. Thanks so much. I hope you can join me again as a guest.
I will.
And,
hope so too.
Yes, and folks, be alert related to these problems. If you have a second family situation, definitely get together with a lawyer, do some estate planning, and I hope you can join us next time at Financial Insider Weekly.